Yes.
Oh, right. Okay, sorry. I was saying thank you very much, Judge Yusuf, and good morning, ladies and gentlemen. I am delighted to take part in today's webinar, and I would like to start by communicating my most heartfelt thanks to the African Institute of International Law, in particular, of course, Judge Yusuf and Ambassador Sani for inviting me to address you today. I hope that my modest contribution to today's conversation will help shed some light on the general issues and challenges that African states and state-owned entities are facing when engaging in arbitration in relation to foreign investments that they host on their soil. So I would like to, if you allow me, share my screen and go over a brief presentation. I would just need a few seconds for that. Can you see my screen? Yes? Okay, great. So as I was saying, I would like to take you through some of the key issues that in my experience arise when it comes to investment-related disputes and arbitration, and in particular, the experience of the ICC. In a first part of my presentation, I would like to go over in a broader sense the investment treaty arbitration under the ICC rules, and then come to the specific issue of the particularities that the African states and state-owned entities may encounter in their engaging into this type of disputes. First, a few very brief figures about ICC. The ICC International Court of Arbitration has been in existence for almost 100 years, since 1923. And as you can see on the chart, on this chart, last year in 2020, the ICC has received a record number of 946 newly registered cases, arbitration cases, with the exception of 2016, but that year the number of newly registered cases was particularly inflated due to 100 of class arbitration cases introduced in the US, so that's an exception. Again, the important information here is that the ICC in 2020 has received over 946 new cases involving a number of different parties, and among them disputes involving African states. When discussing and when covering the issues of relating to African states and state-owned entities in investment disputes before the ICC, I think it's important to make a distinction, and there I would propose two types of disputes that the ICC in its caseload is encountering. The first type in which African states and state-owned entities are involved with respect to the investments that they host on their soil are contract-based arbitration. So in essence, these are not labeled as investment arbitration because they do not arise out of a treaty mechanism being triggered. The second type of arbitrations that the ICC court here are purely investment treaty-based arbitrations. Now, I do think that it's interesting to address both, and although today's discussion has been labeled to focus mainly on those disputes that are investment-based, the reality is that when observing, and in my experience over the past 8 years at ICC dealing with case management in Africa, when you look into those contract-based arbitration, they actually almost, I would say, all of them that involved African states or state-owned entities do relate to foreign investments on the soil of an African state. So, but in the form of a contract, and the arbitration is triggered through the clauses of a contract. And one point that I will come to in the second part of my presentation is precisely that the challenges and the issues procedural issues in particular that are observed when it comes to African states and state-owned entities are mostly the same, whether you're looking at contract-based arbitrations or investment treaty-based arbitration. Now, the caseload of the ICC court is involving not only African states, but more generally states and state-owned entities, is majoritarily composed of the first type, as I was saying, of arbitration, but the number of treaty-based investor-state disputes administered by the ICC court is constantly increasing in a steady manner and has increased over the past 10 years. In particular, in 2012, a study of the OECD showed that between 10 and 20% of the bilateral investment treaties concluded between 1998 and 2010 allow for ICC arbitration for the resolution of investment disputes. That's an interesting information because what it demonstrates is that the ICC is in a way the third most common forum for investment disputes after ICSID and UNCITRAL. And that I think is a trend that we do see or we foresee to go increasingly due to the fact that there is increasing, I would say, reluctance from a number of states to engage in ICSID arbitration. The first investment treaty arbitration under the ICC rules was initiated back in 1996. And there has since been a total of 43 investment arbitration cases administered by the ICC court. In addition to that, the ICC court also acts as an appointing authority whenever a member of an arbitral tribunal, and in general, that would be the president of the arbitral tribunal, is not designated jointly by the parties or according to the mechanism provided for under the treaty, then the ICC court might be called upon to make such an appointment. And that, for example, is the case in UNCITRAL treaty-based arbitration cases. Looking at the breakdown, the regional breakdown of those treaty-based investment arbitrations, one really important information here for our discussion is that Africa and North Africa come as the first region in the world for the ICC investment-based and treaty-based there, I'm talking about arbitrations with 15 cases over the past, since 1996. The second very close region that comes in terms of the number of cases is Central and Eastern Europe. And then following closely are Latin America and the Caribbean. You can see on this slide that Central and West Asia or North and West Europe are much less concerned by those investment treaty-based arbitrations filed with the ICC. Now, I would like to address the procedure for investment treaty disputes under the ICC rules. You've heard from Professor Qureshi a very useful reminder of the basic procedural issues in investment treaty-based arbitrations. The interesting thing under the ICC rules is that there is no particular different procedure that is dedicated to investment treaty disputes, and that is because the ICC rules, as they are flexible enough to adapt to this type of disputes as much as they can cover contract-based disputes. Now, despite that, in 2012, the ICC court has decided to incorporate a number of modifications to its rules in order to take into account the particularities and the needs of arbitrations involving states and state-owned entities, and more specifically to facilitate the administration of treaty-based investments. Those modifications, I highlight three on this slide, are in particular the prima facie determination of a claim that ICC court and ICC and the Secretary General of the ICC are allowed to do under the ICC rules. When it comes to treaty-based disputes, basically the rule at the ICC is that the preliminary screening that the court or the Secretary General normally do would not be exercised in order to allow for an arbitral tribunal to go ahead and do directly the competence jurisdictional determination of its jurisdiction over the alleged investor and the existence of the investment. Now, there has in the history of the ICC treaty-based disputes, there has been two occurrences where there was a derogation to that rule that the ICC would not exercise the prima facie determination. And these were cases in which basically an alleged private investor had introduced a case against a state in one of the instances, against not a state, but against a private party on the basis of an investment treaty. And that private entity had alleged the fact that the respondent in the dispute was basically had substituted itself to the state, and that's why it could use the investment treaty to direct the claims to that party. The ICC court, looking into this specific scenario, had decided to reject the case at the stage of the prima facie determination, and that the case would not move forward to be determined by an arbitral tribunal. But that, as I said, is a very, very limited exception to the rule that the ICC would not apply articles to the prima facie determination under Articles 6, paragraph 3 and paragraph 4 to states and state-owned entities involved in treaty disputes. The second modification that was brought to the 2012 ICC rules to take into account the particularities of treaty disputes is Article 13.4, paragraph A, and that relates to the appointment of the arbitrators in those particular cases. And the variation that was introduced at the time was that instead of going through the normal selection process of arbitrators by the ICC when selecting the president of a tribunal or sole arbitrator, whenever there's no alternative agreed upon by the parties, the ICC court decided to introduce a derogatory mechanism because its default mechanism goes through national committees of ICC court, and those national committees are mostly composed of business organizations in different countries. A number of states over the years had expressed the fact that they were not comfortable with that, and they were perceiving it as potentially a risk of lack of neutrality. Because of that, the ICC court decided that whenever a state or a state party would be involved in one of its disputes, then the ICC court would solely retain the right for appointment without going through this process of addressing first a request for appointment of an arbitrator to a national committee. For example, in a case where there's a need to appoint a Nigerian arbitrator, the ICC court would normally go through its national committee based in Nigeria. If that the Nigerian party that fails to appoint an arbitrator happens to be a state or a state-owned entity, then the ICC court would not go through its national committee, but proceed with a direct appointment of the arbitrator upon selection of the president of the court. The last particularity, I would say, tailor-made provision of ICC rules in 2012 concerning treaty-based dispute was with respect to the emergency arbitration provisions that were introduced in the ICC rules at the time, and for which the ICC court decided that treaty-based arbitrations would systematically be excluded. And for that, it introduced a requirement that the emergency arbitration provision could only be triggered by an applicant when towards a responding party that would be a signatory to the contract containing the arbitration agreement. And by introducing the signatory element into the emergency arbitrator provision, the ICC effectively excluded treaty-based arbitration. That was done again in order to respond to a concern of a number of states that were saying that, and I'll come to that in a few minutes. And those states were expressing the fact that the particularity of their administrations would not allow for a very short emergency proceedings to take place in 15 days. Although it's at the ICC, it is not an ex parte procedure for obtaining emergency relief or conservatory measure. It still is a very short procedure of 15 days, and the particularity of the state with the length that it might take sometimes to look into a given case, be able to instruct counsel, would not allow to participate in such a short procedure. So taking that into account, the ICC court decided to exclude treaty-based arbitration from the scope of ICC emergency arbitration. The last point I would like to address with respect to the particularity of the ICC procedure when it comes to investment treaty disputes are the most recent modifications made to the ICC rules. A new version of the ICC rules was entered into force on 1st January this year. And again, a number of tweaks and they are minor, but they I think are important to make ICC procedure more suitable to investment treaty-based disputes. And so the first of those changes is again to Article 13, which touches on the appointment of arbitrators, and basically you have it on the screen. The new provision here indicates that the members of an arbitral tribunal sitting on an investment treaty-based dispute would no longer have the possibility to be of the same nationality as that of the parties. And here the consideration was one of neutrality and just following the trend of ICSID in terms of the nationality of the arbitrators involved in a given dispute based on a treaty. The second modification to the rules in 2021 with respect to treaty-based disputes is Article 29.6, paragraph C. And again, this touches on emergency arbitrator provisions that I was describing earlier, with simply codifying expressly what was already the practice of the court under the previous article that I exposed. And the last point, which is a very interesting one, I believe, is actually not in the rules themselves, but the ICC note to parties and arbitral tribunals, which provides that for those cases that touch on that are based on that are treaty-based, there is the possibility for amici curiae to intervene in the dispute. Now, coming to the actual issue of this discussion today, what are the issues and challenges, I guess, that African states face when entering into investment treaty-based or contract-based disputes in ICC arbitration? Here, I would try to touch, and of course, on the points that Judge Yusuf has raised when doing his introductory remarks. And of course, I had them already pinned in my presentation. The first point that I would like to address is the geographical aspect of the origin of parties involved in ICC disputes. As you can see on your screen, the African continent accounts for a little less than 7% of the total of the parties involved in ICC disputes. These data are for 2020, so there's a slight decrease in the northern part of the continent. But overall, if we look at the past 10 years, there has been a steady increase in the number of African parties involved in ICC disputes. Now, the particularities of those African parties, you can see here that about 20% of states and state-owned entities represented in ICC arbitrations are 20% of the parties involved in ICC arbitration are states and state-owned entities. When you look at the African region, these figures go up to 25%, and that is telling. And in my experience over the 8 years that I've spent in case management, doing case management of African disputes, I can tell you that a very important share of my work was dedicated to African states and state-owned entities. I would like to stop and mention that those African states and state-owned entities, when involved in ICC arbitrations, are most of the time on the responding side of the dispute. So most of the time, indeed, they would be called into that dispute by, as I was saying in the introduction, a foreign investor. Now, what are the issues that we're facing? I have categorized them in two groups. First, the procedural issues, and then the jurisdictional ones. Whether the arbitration is initiated against an African state on the base or a state-owned entity on the basis of a treaty or a contract in relation to an investment, a foreign investment, we do see similar procedural behaviors that tend to be observed on the part of the state party. And these, I've tried to cover them, and I will provide some specific example. The first and most difficult issue that we encounter is that of the lack of participation. I'm really happy to have Ms. Sekume today with us from Gabon, who will be, I hope, able to share her experience, in the sense that I think that she's part of the, as the head of the contentieux de l'État in Gabon, she's part of those group of states that belong to the exception, meaning that they actually do participate in the disputes where the state or state-owned entities are called as respondent, and don't just wait for the case to proceed in their absence and then wake up with, quotation mark, when it comes to the enforcement. But the lack of participation is still, when it comes to state and state-owned entities in Africa, is still an important problem that is being faced, and in particular in investment treaty disputes. Another point that I think actually maybe even explains that first procedural issue is the difficulties to identify the correct administration within the state to serve with the request for arbitration. And for most of the requests for arbitrations are usually addressed to the ministry in charge of the particular area in which the investment was happening. So, for example, the Ministry of Transportation, the Ministry of Industry or Mines when it comes to mining. But often we see that the claimants and the private investors would omit to include in those requests for arbitration the representative of the Attorney General, which usually are the central office where the disputes concerning the states are concentrated and are being followed. And that does create difficulties for the state to properly be represented. So I guess here, one recommendation, at least from the point of view of the case management institution that I would have, is that the state needs to work on a system of better communication between its administration, among the administration, different administration, to ensure that the information is passed on correctly if the investor is not going to do the work of identifying who should be served apart from the directly involved ministerial offices who should be involved in the dispute. The next issue, an important one that Judge Yusuf has touched on when opening, is the question of the choices of the representation of the state. Here, I completely subscribe to what was said previously by Professor Qureshi. In most of those African cases, the choices made by the states are to go with outside counsel, international-based outside counsel. I do not necessarily think that that is a bad thing. However, what I think that it would be an interesting model that we see from certain states, for example, the state of Senegal does that, is to systematically have a pairing between, if there is going to be an international team of representatives for the state, then there should be a local team to also be involved in that dispute, not just actually for capacity building purposes, which are extremely important. At some point, the ability to represent the state has to be refocused in African hands. But I think that it's also because in a lot of those cases, and that comes to the first point that Judge Yusuf has addressed, the applicable law chosen, at least in ICC arbitrations, is often that of the African state. and not an outside applicable law. So when that, and I'm not talking about, of course, international provisions that would apply in terms of determining the identity of the investor, the existence of the investment, etc. I'm talking here about the law applicable to the merits. Interestingly enough, while African states would forego the choice of the place of arbitration to be placed outside the continent, they managed to get the law applicable selected to be that of their country. Then the problem becomes, how does international counsel, non-African counsel, have proper understanding, reading of the applicable law and application within the case and plead it properly to the tribunal? And that has, when doing ICC, as you know, ICC court does the scrutiny of awards. And when we proceed to that exercise of scrutiny in those African disputes, in a number, too many of those cases, the ICC court comes to the conclusion that the arbitral tribunal ends up applying rules that do not belong to the law applicable. But because both counsel teams were not African counsel team, were not in the know with respect to the law applicable, they in a way tacitly modify the choice of applicable law by pleading under a different regime. So for example, if you have a case involving the law of the Democratic Republic of Congo, I can assure you that you will systematically see outside counsel pleading that case under either Belgian law or French law, systematically. But because both sides would agree to do it spontaneously, then the arbitral tribunal finds itself in a situation where it has to apply that law, which becomes the consensual choice of the parties. So, of course, in the scrutiny process, the ICC court will try to draw the attention of the tribunal to that incoherence in a way between the initial choice of the parties in the contract and what the procedure has emerged while the procedure goes on. But I guess the best way to tackle that is simply to involve a counsel who understand the applicable law and are able to properly plead it in front of the tribunal. I see that I'm seriously running out of time, so I will move to the next 2 slides that I have, and I will stop there. The place of arbitration, I was mentioning it. Interestingly enough, in most investment treaties dispute that were referred to ICC, the place of arbitration is not predetermined, but it often, the provisions of those treaties often allow for a selection by the investor between 2 different places. So one example you have on the screen would be, for example, that the dispute would be seated either in London, UK, or in Tripoli, Libya, in a case, obviously, that's an example pulled out from a treaty involving the state of Libya. When that case is presented, however, we systematically obviously see the selection go towards London. In those cases where the place of arbitration is not predetermined under the ICC rules, there's no default place of arbitration. The ICC rules allows for the place of arbitration to be selected by the court in any given place. But, and that's important, despite the fact that there's no written rule in terms of selecting the place of arbitration, what I've noticed looking into those investment treaty cases is that whenever the court proceeds to the determination of the place of arbitration, it will select Paris. I think that I only found one exception to that rule over all of the cases that I have reviewed. And I think the reason, obviously, for that is that the court would go for a neutral place of arbitration, also one that is arbitration friendly, obviously, for the arbitration award, with the concern that the arbitration award ultimately be capable of being enforced. And so there again, indeed, there could be a reflection done on the choice of the place of arbitration at the time of entering into those treaties, in particular, because nowadays, I think nobody would dare say that the arbitration legal framework in most African countries would not allow for them to be qualified as safe seats. Now, of course, there is still tremendous work to be done in terms of training of the judiciary to make sure that the law is then that those appropriate arbitration law are then properly applied by the judiciary when it comes to reviewing or examining enforcement of arbitral award, rather. I will stop here. I haven't been able to address the jurisdictional issues, but I'm sure that in the Q&A, we will have a chance to come back on that. Thank you so much for your attention.